that was the side of them. Uh, Really, it was just, I'll contend, my Lord, that that was done to appease them, to kind of find a way to keep the peace. I was trying to assure them
It was at this point that Mr. President Richard, counsel for the accused person, made an application to this court while relying on Article 28 of the Constitution, that's the right to a fair hearing, and Section 46(1) of the Trial on Indictments Act. He asked the court to call the doctors in Mutarika because from the evidence on record by the prosecution, it was indicated that the accused had a history of mental illness. We also asked this court to make an inquiry into the mental health of the accused pursuant to Section 46(1) of the Trial on Indictments Act. The father stated that this government institution, that is Mutarika, would be in a position to tell us whether the accused has ever been in Mutarika in his life and his health status, and they will also be able to tell us whether he is capable of following the proceedings and to be put on his time, much as he has finished. I need to observe from the onset that I find this application in the middle of the testimony of DW2 with almost no background information being irregular. I'd rather counsel waited for the witness to first give his evidence, whereupon he would have sufficient information upon which to base his application. Nevertheless, I will proceed to address his concerns. In reply, Mr. Jonathan Mwaga, the Chief State Attorney, by citing Section 46(1) of the Trial on Indictments Act, contended that this application is rather strange and was brought too late. He argued that the provision of the law, that is Section 46(1) of the Trial on Indictments Act, relates to the capacity of the accused person to follow proceedings during trial. He argued that an application under this section should be brought before the accused's face and not after. While citing the case of Omaka Geoffrey versus Uganda on the 9 of 2017, he submitted that the capacity to stand trial when the person has capacity to stand trial when he is able to do one or more of the following. A, that he understands the nature and consequences of the proceedings, and that he can communicate with his advocate in the sense that he is able to take part in his own defense. He further argued that the two separate questions to ask is whether the accused is able to understand and plead the indictment against him, and whether he would be able to take an effective part in the trial. He further stated that this was for court to decide and not the doctors. That is from that decision. And now this is the decision of the court. Section 46 of the Trial on Indictments Act is under Part 7, which provides for procedure in case of mental illness or other incapacity of the accused person. Subsection 1 therefore provides that, and I'm quoting, when, in the course of a trial, the High Court has reason to believe that the accused is suffering from mental illness and consequently incapable of making his or her defense, it shall inquire into the fact of such mental illness. In the case of Omaka Geoffrey versus Uganda, which the prosecution relied on, I am persuaded by the decision of the Land Honorable Justice Stephen Obiyu regarding what to look at when to determine whether a person is capable or not. He says a person will be capable of standing trial where he is able to do one or more of the following: understand the nature or object of the proceedings in the sense that he is able to understand that he is in a courtroom, recognize the people in the courtroom, that is, the judge, the state attorney, his advocate, and why they are there. 2, understand the possible consequences of the proceedings. That is to understand what he is charged with, what kind of pleas he can take, that he is guilty or not guilty, what can happen to him if he pleads guilty, or what can happen if he does not tell the truth in court. 3, communicate with his advocate in the sense that he is able to take part in his own defense and tell his advocate, even in basic terms, what he wants to do with his case. When this matter first came up on the 30th of April 2026, this court interfaced with the accused person for the first time. I extended my greetings to him and he respectfully responded to me. I informed him that there were some charges against him and I needed to tell him his rights to a fair hearing under Article 28 of the Constitution. I explained to him his right to presumption of innocence and the right to be legally represented, among others. I informed him that 2 lawyers had been assigned to him to assist him in these proceedings. I also informed him that if he had anything to ask or communicate, he would communicate the same through his lawyers or he would speak to the court directly. I then asked him if he had understood, and he answered in the affirmative. Since then, the accused person has very well exercised those rights, right from the time of taking plea to the time of giving his defense. The accused exercised his right to plead not guilty to all the 4 counts, and in fact, when I first asked him, while explaining to him the particulars of the first count, and I asked him whether it was true, he asked me, "Do you mean my plea?" And when I said yes, he went ahead to say, "I plead not guilty." This pattern followed through the other counts. I have observed him throughout the proceedings, and I am satisfied that he was alert and keenly following the proceedings. Occasionally, whenever he had something to communicate, he often raised his hand, and I would either ask his lawyers to attend to him, and then immediately I would ask the lawyers whether they had a communication to make to court from the accused person. However, on other occasions, he raised his hand, and his lawyers would tell me that he wants to address court personally. Whenever I gave him a chance to speak, I did not find anything irregular with his speech, which would have given me reason to believe that he is suffering from mental illness and incapable of following the court proceedings and eventually give his defense. When the prosecution closed its case yesterday, the 23rd of April 2026, and after filing the prima facie case against the accused on all the 4 counts, thereby requiring him to give his defense, I explained to him the options that were available to him to make his defense pursuant to Section 74, subsection 2 of the Trial on Indictments Act. I then asked him if he had understood, and he said that he had understood. I specifically asked the accused person to repeat what he had understood, and he accurately explained it back to me. I gave him 30 minutes to consult with his lawyers and informed the court which option he would take. When court resumed, he informed the court that he wasn't quite ready, but said he would give a sworn testimony. Regarding his witnesses, he informed the court that he needed to get their particulars in his 3 phones, 2 smartphones and 1 button phone, which he clearly described. The said, which were already admitted as prosecution exhibits, were availed to him, and he was given time to scroll through them, upon which he wrote 4 names and telephone contacts on a piece of paper for court to summon them. I am glad to note that the defense has informed the court that 2 out of the 4 witnesses whose particulars were availed to court were duly summoned and are present in court. The current witness, GW2, who stated that is the accused's brother, being one of them. After the accused informed the court that he would give a sworn testimony, I again gave him an hour to prepare himself. And when court resumed, he still informed the court that he was still not yet prepared to give his defense. I then reminded him that if he gave a sworn testimony, he would be subjected to cross-examination by counsel for the state. And then he responded, "In that case, I will give an unsworn statement." The matter was then adjourned today, the 24th day of April 2026, when he gave a detailed and sworn statement. The accused asked whether he could consult his notes while he gave his defense, and his request was granted. He then took out his notes and kept on making reference to them under different subjects. He also occasionally made reference to the evidence of the prosecution and going ahead to rebut it with his own evidence. He repeatedly stated that he did not deliberately kill the 4 children, but he was under the control of some people whom he said were in 3 categories. The accused further stated that between the months of January to March this year, he was in distress as a result of those people who were surveilling him, and he understood that they will prevail over him. I am satisfied that this is his defense, which the court will analyze in light of the other evidence on record at the time of giving judgment. Throughout the trial, it has been, of course, clearly said that the accused person suffers from chronic sickle cell anemia disease, which affects his body. It does not affect his mental abilities. In light of the above verified, in the course of this trial, I have had no reason to believe that the accused is suffering from any mental illness, which would make him incapable of making his defense, thus requiring me to inquire into his mental abilities. I have watched the accused throughout the trial, and I'm satisfied that he has been following the proceedings right from the beginning. I therefore decline to make an inquiry into the mental health of the accused person as requested by his lawyers. Counsel for the accused has also asked this court to call the doctors in Butarika. Unfortunately, he did not specify which doctor this court should call. He also stated that the doctor should tell us whether the accused has ever been to Butarika Mental Hospital. Unfortunately, he also did not specify which period. It is important to note that DW2 is the first person to mention that the accused person has ever been in Butarika. The accused person himself, while giving his defense, never mentioned at all that he had ever been in Butarika. The mental distress he talked about while giving his evidence was between the months of January to March 2026. Counsel for the accused made reference to PF24, which was marked as a prosecution exhibit PEX7. That was the examination of the accused person on his physical and mental abilities done on the 7th of April. Those were five days after the alleged offense happened, by Dr. Norman Emmanuel, who is a police surgeon but also a psychiatrist. He informed the court that he assessed the accused person, and these were his findings, and I'm quoting. He had normal behavior, calm, cooperative, speech was coherent, his memory intact, and exhibited good judgment. His thought process and content was normal, but believed in wealth by human sacrifice. He was able to explain the reason for killing the children as fortune hunting or enrichment. He got the idea on recalling childhood folk tales of getting wealth by sacrificing people. In that report, Dr. Nwamanya made a note as information from the accused, and I'm also quoting. He had a history of past mental illness, treated between 2016 to 2025 for schizophrenia associated with both auditory and visual hallucinations. He killed his 2 to 3-year-old brother in 2016 or 2017, reportedly to save him from the troubles of this world. He also attempted suicide in 2023, and he was also a sickle cell patient on treatment. The findings above are suggestive of a mental condition with psychotic episodes. Further mental assessment is necessary since no medical documents were availed, and he was the only source of information. From the above information, Butarika is not mentioned anywhere. The defense has not given this court any information regarding the mental health of the accused person in light of the presumption of sanity under Section 10 of the Penal Code Act, Cap 128. Having said that, I reiterate that the only person that has mentioned that the accused person has ever been to Butarika before this court is DW2. I am unable to make an order requested for by the defense lawyers on behalf of the accused to call a doctor from Butarika before hearing the full testimony of DW2. In the meantime, DW2 shall continue his testimony whereupon the court will make a decision as whether it is necessary to call somebody from Butarika or not, but it will only be restricted as to whether the accused person has ever been to Butarika, but not to make an inquiry as to whether he is capable of standing his trial. And that is the order of the court.
Lead Wakala.
kusaba kwe ng'asaba nti kkooti ewa ekiragiro kkooti etumye bayite omusawo kuva ebutabika ajje obujulizi oba okera ategeera bulungi oba nedda era n'aba gavumenti n'eddamu n'asaba n'agamba okusinziira okusaba wekujjidde akuwakanya n'okuba nti esaawa ebakuleetedde ng'okera amaze okuba obujulizi okuweerezaako okwe era tewaliwo nabukakafu buleeteddwa budda bwalabirwa era omulamuzi akyekennenyeza nayetegereza n'obujulizi obwaleetebwa edda n'agamba nti okusinziira n'engeri gy'abadde ayogerezeganyaamu n'okera okuva omusango gwe gwatandika nga 13 omwezi guno tannazuulawo nsonga yonna emwaliriza kubanga anoonyereza ku ntegeera y'okero yagamba nti obujulizi bweno omujulizi owokubiri oludda olwalabirwa agende mu maaso n'obujulizi bwe olwaleero. So will you please resume your stand? Mr. President, never understood.
Thank you, my Lord. Defense has successfully led the defense witness, and we close our evidence in respect of that witness. We pray prosecution goes ahead to cross-examine.
You're telling me that was not needed from him?
My Lord, I've said in respect of this witness.
What is needed from this witness?
Yes, my Lord.
Okay. Do you have any cross-examination you want to make? Counsel for the state?
So I'm going to ask you a few questions. Your brother, I just want you to confirm that your position is that your brother was in Butabika in the year 2020. Is that your position? Yes, sir.
Asante muganda wange yali mudwaliro ly'Ebutabika mu mwaka 2020.
But you don't know the reason why he was taken there, do you? of Dare, he had killed a stepbrother called Freeman. Is that something in your knowledge?
I have heard. It's not something that I'd say is in my knowledge.
What have you heard?
I had heard that, as Council had mentioned, that he had killed the person called Freeman.
Freeman is supposed to be your brother, a son of your biological dad. Do you still want this court to believe that is the fact not in your knowledge?
I had not met my little brother before.
So you are not aware whether he's alive or dead?
I am aware that he is dead.
Nawulira buweereze nti nali nkiwuliddeko nti muganda ono yakuba omuntu ayitibwa Freeman ng'era nti omuntu ya Freeman yafa.
And from Butabika, as you say, your brother, the accused person, went straight to the United States. Do you know when he went to the US?
No, I do not.
Simanyi ddi muganda nga yagenda mu America.
So other than today, when did you last see the accused person?
Physically, the last I saw him was
Which year?
other than today.
Yes.
Other than today, the last I saw him was in the evening of the night of April 2nd.
Was this after his arrest?
Yes, that was after his arrest.
Ojjako leero lwe nasemba okulaba muganda wange ono maaso ku maaso namulaba ng'amaze okukwatibwa akawungeezi kanga 2 omwezi ogwokuna.
Okay, other than the night of April 2nd when he was arrested, when had you last seen him?
It has been long, I cannot.
In terms of years, can you estimate for this court in terms of years?
About 5-6 years.
Ojjako akawungeezi k'olonga 2 omwezi ogwokuna naye nasemba okulaba muganda wange mu myaka wakati w'etaano n'omukaaga emabega.
And I'll be correct to observe that even though you are biological brothers, you are not close associates. You are not close friends. Will my observation be correct?
Yes, that would be correct.
Wadde tuli booluganda naye tetuli muba mu mukwano.
Well, finally I'm instructed that actually, okay, before I tell you my instructions, confirm to this court that when your stepbrother Freeman was killed, the accused person was never produced in any court of law for that matter. You know that fact?
No.
Was he produced in any court of law to your knowledge for that matter?
I do not know that.
Testimony called one Uganda and the Uganda Kutiwaka during the same man. Atwali wako mkoza mateka nsonga.
Our second last question with you, sir. You don't actually know under what arrangement your brother was taken to Butabika. Is that correct? You don't know who and under what arrangement he was taken to that place called Butabika. That is correct.
Tufu simanyi ani oba ntendo ki mubayita kutwala muganda wange Butabika.
In fact, you, as your brother, even when you attempted to go there, you never saw him physically to confirm that he was there. Is that correct?
The question is that when you went, did you see him? Did you see your brother?
Yes, I saw him.
You found him there.
Yes.
Nagenda ye Butabika muganda wange namulaba era namusangayo.
Now, our instructions is that after your brother committed a heinous crime for the murder of three men, Butabika was used as a scapegoat, and he was taken there without following due process, and from Butabika he was whisked out of Uganda, and his presence, his production in Butabika was on purpose to escape the due process. What do you have to say about our instructions?
My lord, I have something to say about the question.
Please go ahead.
My brother should be clear about the instructions.
Mr. Kiro wants to say something. You first approach him. Yeah, this road has been up for quite some time. Let's hear what he's saying. You don't want me? Who do you want? You want to talk to me? You want to ask me? Please go ahead. Give him a microphone.
Yes, my lord. So, my lord, can I ask the witness any question? A question? Or maybe three?
You want to cross-examine your own witness?
Another request is that my land colleague should tell the witness the instructions, and he goes ahead to continue with that question.
Thought he did not. You want the specificity of the instruction.
Yes, was
Actually, I
was
think I
authorized.
wrote the instructions from the question. It says he has instructions that he was taken to Tarifa after killing Freeman to escape the due process. And from Tarifa, they actually whisked him to the US. That is what I thought he said.
Yes, my lord, but that's a statement, it's not instructions.
And then he was now going to ask a question. Those were the instructions, and he was going to ask a question.
So my lord, I agree that my learned colleague gives the instructions he was given, then he goes ahead to answer the question.
Okay. I thought that's what you are doing. Listen what I have had. You have instructions, you cannot put a question for witness.
What do you have to say about my side instructions?
You have an answer to the question?
No, I do not have an answer to the question. My lord, that's all.
That is all. And then next one, Mr. Principal.
No one will
I
examine
think the
it.
question that he wanted to ask him, he can give it to you, and then you will examine the witness. You can go and put to him. Yes, the next one.
My lord is insisting on asking him questions.
No, I will not allow him to cross-examine his own witness because he called him. And that is why he's there. But I have some few questions to ask you, sir. So you say it's your biological brother and you share both parents. Are your parents both still alive?
Yes, both our parents are still alive.
Bazadde baffe beebamu, maama ne taata era bakyali balamu. They live in Uganda.
Yes, they do.
They babeera mu ggwanga Uganda. And you said that you last met your brother, the most recent encounter was after his arrest.
Yes, that is correct.
Era kituufu nasaba okusinkana muganda wange ng'amaze okukwatibwa.
But if I can clarify, I saw him. We did not meet.
Omulaba obulabi naye tetwasisinkana. Where did you see him?
That was at Kabalagala police station.
Omulaba ku police station y'e Kabalagala. Which date was that?
On the 2nd of April this year.
Malinga bbiri mwezi ogwokuna omwaka guno. At what time?
I don't remember the exact time, but it was between 8:30 p.m. and 10 p.m.
Sijjukira essaawa zennyini naye zaali wakati wa ekitundu ez'ekiro n'essaawa 4 ez'ekiro. And how did you end up in Kabalagala?
I had work in Ginger.
How did you go there? Who told you to go to Kabalagala?
I received information that he seemed to be the person they were talking about with this occurrence. And then I went to the police station to confirm.
Nafuna amawulire aleka ye muntu era akoze bino byali bituuseewo era naye nengenda ku poliisi y'e Kabalagala kakasa. Who gave you the information?
I found out from my wife.
Amawulire gano nagamanyira ku mukyala wange. When you reached Kabalagala, you said you didn't meet him, you just saw him on the tour.
No, we did not talk.
Natuuka ku poliisi y'e Kabalagala saayogera naye. About this visiting Tabitha that you talked about, are you able to remember her date?
The exact date, no. I just remember the reason I remember is shortly after the visit, then we had the lockdowns.
Sijjukira nnaku za mwezi zennyini naye kyenzijjukira nti oluvannyuma lwayinza okugendayo Tabitha ne wajjawo omuggalo. So who told you that he was with Tabitha?
We were supposed to have had a family meeting, a get together in December 2019, and during that planning process, I was trying to check with my mother because I couldn't reach him, and that's when I heard that from a friend that maybe, another brother.
Twali tulina okuba n'olukuŋŋaana nga famire naye mu nteekateeka twalina okuba n'olukuŋŋaana olwo Desemba ya 2019 okubuuza maama wange. So what other brother told you that?
I'm trying to reach him because that during that time he should have also been in touch, and then that's the one who told me that he could be somewhere in Kampala, maybe at the hospital.
Muganda wange omulala twalowoozaganya ye yategeeza nti alina okuba ng'ali Kampala Onokero era nga tegeezebwa okuba ng'ali mu ddwaliro. So when you reached there, what did you talk to?
I had initially tried to meet the house was sensitive, and I was not able to meet him.
What did the DHS tell you?
That the case under which he was brought in was sensitive, and I have not been in position to meet him.
What was sensitive?
Sorry?
The case was sensitive.
Yes, please.
Twandikwanageza okwogerezeganya n'abaddukanya eddwaliro eryo olw'uko yali akolera mu kitundu ekyo ssaawa eyo.
No, I did not meet him, but while walking in the compound, I was able to see him in one of the wards.
Walking in the compound, and then you saw the what?